In February, the court temporarily blocked the law from going into effect after an emergency request was filed by CRR. The group says that if the law is permitted to stand, it will shut down 2 of the remaining 3 clinics in Louisiana. Today, we asked the Supreme Court to step in to stop Louisiana from blatantly ignoring the court's most recent ruling on abortion rights. In 2016, the court was crystal clear that states may not use medically unjustified restrictions to shut down abortion clinics, said Nancy Northup, President and CEO of the Center for Reproductive Rights. The stakes in this case couldn't be higher for Louisiana women, where abortion access is hanging by a thread. If states are allowed to disregard Supreme Court decisions, the constitutional protections of Roe v. Wade are in peril. Restrictive state abortion laws intended to provoke a challenge that could lead the Supreme Court to overturn Roe v. Wade have picked up speed since the confirmation of Justice Brett Kavanaugh gave the High Court a presumed anti-abortion majority. Since January, more than 300 anti-abortion bills have been introduced in state legislatures, with many of those directly challenging existing court rulings protecting abortion rights. There are 2 possible paths for abortion foes. The first is to prompt an out-and-out rescinding of Roe. 6 states have passed so-called fetal heartbeat bills, which ban abortion after the 6th week of pregnancy before most women even know they are pregnant. In total, the number of such laws introduced at the state level this year has increased 63% from the year before. To uphold these bills would mean directly overturning Roe, which allowed for the procedure until the point of viability, which at the time was considered the start of the 3rd trimester. The second is to leave Roe in place, but add so many regulations that access is effectively impossible for most women. It is one such bill, Act 620 in Louisiana, that is likely to be the first piece of abortion legislation to reach the court since Kavanaugh replaced the swing vote on reproductive rights, Justice Anthony Kennedy. In 2014, Act 620 passed and was signed into law by Louisiana Governor Bobby Jindal. The law was immediately challenged by CRR, which said it placed an undue burden on abortion providers. Hospitals give admitting privileges to doctors who send them lots of patients. It's a business relationship. Abortion providers don't send patients to hospitals because the procedure is so safe, Tuesday says. The bill was introduced by Democratic State Representative Katrina Jackson, who told News Pulse News, "When I ran for office I told everyone that I'm going to pray, I'm going to hear from God, I'm going to let my Christian values direct me." When asked if she stands with President Trump on abortion, she said, "Although the president and I disagree on a number of issues, trust me, I do support his stance on abortion and being pro-life." Before Act 620 was passed, there were 3 clinics in Louisiana, down from 7 in 2006, requiring many patients to travel long distances and incur the expenses of transportation, child care, and lodging. Supporters of laws like Act 620 say this is all about women's health, and that's just a lie. These laws are about shutting down clinics, Tuesday says. Video produced by Samantha Feltus.